Welcome to this AIM Quick Guide to Oaths of Office and Surety Bonds and some first steps that might be helpful to you as you navigate what can be a complicated process. As with all of AIM's Quick Guides, they are intended to offer members an introduction to the topic. These quick guides should not be considered legal advice and should not be considered the single source of information regarding a particular topic. Should you need further assistance, please don't hesitate to reach out to us at aimindiana.org, and we'll be happy to link you with additional resources. Let's get started. Indiana Code says every officer and every deputy, before entering on the officer's or deputy's official duties, shall take an oath to support the Constitution of the United States and the Constitution of the State of Indiana, and that the officer or deputy will faithfully discharge the duties of such office. The Code does not directly speak to which positions in municipal government are required to take oaths of office. However, over time, the courts have provided guidelines as to what positions are those of an officer. Here are two tests the courts have used to assist in determining whether a person is an officer. One is whether a person holds an elective or appointive position for which public duties are prescribed by law rather than contract, and the office holder is invested with some of the functions pertinent to sovereignty. Another is whether a person has powers of supervision and control and has liability to be called to account for malfeasance in office. Under these tests, all elected officials and most appointed board and commission members and department heads would be considered officers and would be subject to the oath requirement. One court case held that law enforcement officers were clearly included in the oath requirement. Also, there are many statutes that specifically require persons in positions to take an oath and file it, such as redevelopment commissioners, park commissioners, utility service board members, sanitary district commissioners, and more. When in doubt, check the statute and consult with your city or town attorney. An individual appointed or elected to an office of a political subdivision may take the oath at any time after the individual's appointment or election, but the person must take the oath and deposit a copy with the Circuit Court Clerk's office no later than 30 days after the beginning of a term of office. For example, if your term begins at noon on January 1st, 2020, you must take and file your oath by noon on January 31st, 2020. If you do not, you will lose your office. Newly elected officials and incumbents will need to take the oath and file it. Since some department heads could be viewed as having a term of office no longer than the elected officials appointing them, they too should be administered the oath regardless of any carryover status they may hold. So, who can administer an oath? Here's a list that includes a number of different officers. Notaries public, judges of courts in their respective jurisdictions, Indiana Secretary of State, Indiana Clerk of the Supreme Court, mayors in their respective cities, clerks and clerk treasurers of cities when necessary in the discharge of their duties in their respective cities, clerk treasurers of towns in their respective towns, township trustees in their respective townships. An official cannot administer an oath to himself or herself. Oaths of office are to be endorsed on or attached to the commission for city or town court judges, or certificate of election signed by the person taking the oath and certified by the officer before whom the oath was taken. The officer who administers the oath is responsible for delivering a certified copy of the oath to the oath taker. Once elected officials, except for city and town court judges, receive the certified copy of the oath, a copy of it must be filed in the office of the Circuit Court Clerk of the county containing the greatest percentage of the population of the political subdivision. For city and town court judges, state law appears to require the commission and oath be filed with the Secretary of State. It certainly would not hurt if the judge also files a copy with the county clerk to avoid any arguments of statutory ambiguity. State law requires that many of the municipality's officials give bond as a requirement for holding office. This refers to the security of a surety bond that serves as a pledge to reimburse the municipality against costs or other losses occasioned by wrongful or negligent actions. City and town judges, city controllers and clerks, and all clerk treasurers are required to file a surety bond. Employees and contractors of the municipality, whose official duties include receiving, processing, depositing, disbursing, or otherwise having access to federal, state, or municipal funds, must also file a surety bond. The municipal public officials bond ordinance could and should direct what other employees are to be bonded. Bonds are to be filed in the office of the county recorder or in the county of residence of the official and with the municipal fiscal officer. Municipal officials and employees who are to be bonded can be covered under a blanket bond or a crime insurance policy with a faithful performance endorsement instead of a surety bond if there are proper aggregate limits and the council has passed an ordinance allowing it. Each bond or crime insurance policy must have a term of 1 year commencing on the first day of the calendar year or the municipality's fiscal year, or the first day of the individual's service in the office or employment position for which a bond is required. Consecutive yearly bonds filed by an individual must provide separate coverage for each year in the required amount. The aggregate liability of the surety or insurer providing the bonds or policy for the policy year covered is the sum of the amounts specified in the bonds issued by the surety or insurer for that policy year. All official bonds shall be payable to the state of Indiana. Officers required to give an individual bond shall give the surety bond or crime insurance policy before the commencement of their term of office. If an officer fails to give the bond before that time, the official may not take office. The respective common or town council is required to establish the amount of surety bond to be filed by the municipality's fiscal officer in accordance with a formula established under statute. The council's public officials bond ordinance should provide an amount required for each bond. It should also direct what other positions, officials, and employees should have a bond and whether the bond is an individual or blanket bond or a crime insurance policy. The surety bonds of city officials, except for that of the mayor and the members of the common council, must be approved by the mayor if they are sufficient. Surety bonds of a city board of works or a city board of works and safety must be approved by the common council. Surety bonds of the town marshal and a town clerk treasurer must be approved by the town council. If a surety bond is subject to approval, it must be approved before it is filed. A bond shall be filed with the county recorder and the fiscal officer within 10 days of its issuance or, if approval is required, within 10 days after its approval by the person required to approve the bonds. All public official bonds or crime insurance policies filed with the municipal fiscal officer shall be filed with the State Board of Accounts through Gateway. Thank you for viewing this AIM Quick Guide to Oaths of Office and Surety Bonds. Again, please note that our quick guides are intended to offer AIM members an introduction to the topic. These quick guides should not be considered legal advice and should not be considered the single source of information regarding a particular topic. Further, this quick guide was recorded in November 2019. Information contained herein was accurate at that time. Should you need further assistance, please don't hesitate to reach out to us at aimindiana.org, and we'll be happy to link you with additional resources. This AIM Quick Guide is sponsored by O.W. Cronin Associates, a firm of certified public accountants and SEC-registered municipal advisors who have been serving the financial needs of Indiana cities and towns since 1986. Cities and towns face a broad range of financial requirements, starting with the need for basic training and education for elected officials. The seasoned partners and staff at Cronin Associates have helped local officials wrap their arms around the myriad of financial issues that are essential for good governance. Financial planning, accurate reporting, realistic budgets, adequate and fair utility rates, and a comprehensive understanding of Indiana's municipal financial model for securing the capital that your community needs to achieve its goals represent the core services provided by Cronin Associates. Visit us at owkcpa.com or call anytime 317-867-5888. We're at your service 24/7, 365 days a year.